decision has been taken by the Bombay High Court. It has upheld the reservation for the Maratha community. The court also upheld the report that was filed by the State Backward Class Commission, court accepting here that reservation but did not accept the quantum of 16%. So this is the observation here that is coming from the court, saying that in exceptional situations, the 50% cap, the existing 50% cap as per the Supreme Court being can in fact be exceeded, but 16% reservation not justifiable by the Bombay High Court. We have with us our correspondent Santhya getting us those details here. Santhya, this is partial relief. The court observes that yes, reservation is required, but 16% is too much. It seems that the state government now once again will have to reconsider that percentage.
The Bombay High Court has cleared that the community, based on the report of State Backward Class Commission, is eligible for reservation, but as far as the quantum of the reservation goes, 16% is not justifiable, not acceptable. That's what court said. Later on, court added that because the community was added into socially and educationally backward class, based on that, the community is eligible for reservation, 12% reservation when it comes to educational quota, and 13% reservation for the jobs quota in the government institute. So that's how Bombay High Court has divided it up for the community, and the state is likely to follow the instructions, or the state has to follow the instructions of Bombay High Court on this.
That's right. Santhya, it's not just a question of the state government now having to follow, but even the Maratha community that had been protesting was very sure about the figure. 16% was their demand, and they will now need to reconsider this as well.
See, what exactly Maratha community is going to do, what's their next step, that is something they are yet to decide on. But as of now, of course, they started chanting slogans outside Bombay High Court building. That shows that they are not completely unhappy about it. But whether or not they are going to approach Supreme Court against this order, that is something which, of course, we have to wait and watch. And the original petitioner.
That is something which, of course, we have to wait and watch. And the original petitioner who opposed, who challenged the reservation which was given to Marathas in the first place, whether or not they are going to approach Supreme Court, again, for that we have to wait. As of now, they are yet to come out and give a word on that. But as of now, Maratha community, after a struggle of decades, which is like almost 4 decades. They started their protest in 1980. The demand of Maratha reservation came first in 1980. Now they have finally got a final order as far as Bombay High Court is concerned. Community, according to Bombay High Court, is eligible for reservation, but not based on caste. It's based on the Backward Class Commission's report, which puts them into socially and educationally backward class. They are eligible for 12% reservation in education and 13% in jobs.
That's right. This is, of course, based on what the court feels as far as coming under the SEBC category, which you specified here. Santhya, but how we still don't know whether or not either party would want to go ahead to the Supreme Court on this decision by the Bombay High Court. But currently, the immediate effect of this on ground, because the government last year had already passed this reservation. It has impacted the scene as far as education and jobs is concerned. So what is going to be the immediate effect of this then?
See, if we talk about the immediate effect and if we talk about the political one, it's going to be very beneficial for Devendra Fadnavis-led government, because before this also in 2014, keeping the then assembly elections in mind, Congress NCP-led government did provide a 16% reservation to Marathas. But again, that was based on caste, and that was one of the reasons when Bombay High Court put a stay on it. They said that the reservation cannot be caste-based. So that one thing was addressed by the Maharashtra government while appointing this particular panel, and while the panel, while studying 43,000 families as a survey, as a part of their survey sampling, they
absolutely. Santhya, please stay on with us. We're getting in a quick reaction here. We have with us Advocate G. Sadavarte with us over the phone line, who's also, of course, one of the petitioners in this case, had moved against the Maharashtra state government's decision here on this reservation. Thank you for being with us. What do we expect next? Are you to continue with that argument here as far as reservation is concerned, or are you convinced with what the High Court has stated, taking into account both arguments and drawing that balance?
First of all, I will put the words in a very simple manner. In the present matter, judicial discipline was lost. The thing was that when we mentioned it to specifically to Honorable Chief Justice Dan Patil, that Honorable Justice Ranjit More may not hear this matter, as he was already passed an order that Advocate Sadavarte's matter will not be heard before him, even the petitioner's case. Thereafter also, I don't know under what influence, thereafter, without following a judicial discipline, the matter was taken up by the Honorable Justice Ranjit More. So one thing is that judicial discipline was lost in the present matter while hearing the bench headed by Honorable Justice Ranjit More. Second thing I would like to put it this, that whatever today the verdict has been delivered by the Honorable Division Bench, we feel that aggrieved that only such type of judgment is not only unconstitutional, we feel that which violates the right, and we have a right to criticize it, and we have a right to challenge it. Earliest, for the betterment and for the general category students, we are going to challenge in the Supreme Court.
Right. So please explain, why do you think this is unconstitutional? Because the High Court also making it very clear, as per the argument that is put forth on what the Supreme Court has decided, that the 50% cap cannot be breached. The High Court here also saying certain exceptions need to be taken.
Yeah, Supreme Court time and again has very categorically said that more than 50% the quota can't exceed. But in the present matter, the court was very well known that only 22% seats for the general talent of this nation was left. And that in that scenario, the court was supposed to follow the judicial discipline and judicial pronouncement of the Honorable Apex Court under Article 141 of the Constitution of India. It seems that due to the influence of the Devendra Fadnavis government, sorry to say, but it is a time to meet somewhere and somewhere.
This is a very strong charge.
Of the judiciary.
This is a very strong charge, saying that there has been judicial indiscipline, there has been an influence, political influence of the state government. We're going to be tapping on that in just a bit. For the moment, of course, we're going to be getting into more details on what exactly the High Court has stated and how this affects the Maratha community. Let's get in a very important word there from the Maratha community. Rajendra Dorde, Maratha Kranti Morcha, member of the Morcha with us. Rajendra Dorde, are you satisfied with this decision, or do you still want to continue in pressing on with that demand of 16%? The High Court says it needs to be brought down to 12% for jobs, for education, 13% for jobs. Are you satisfied with that?
No, madam, that is the decision of the Honorable High Court, so I cannot say any comment on that. It is now the decision of the Maharashtra government to decide whether to give 13% or 16%. But right now I am hearing on your channel, Advocate Sadavarte, saying that this is unconstitutional and the Honorable Court has done something. I strongly...
Rajendra Dorde, we'll get to that point in just a bit. We'll get to that point in just a bit, but very quickly, if you think that the state government chooses not to go to the Supreme Court, decides to go along with what the Bombay High Court has decided, the reservation will be shot down 3%. Are you fine with that?
No, fine with that or not is a different subject altogether, because it is a small cap of 2 to 3% in education.
No, I'm specifically asking, Mr. Rajendra Dorde, I'm specifically asking because the 16% figure was a demand that was raised by you and other members of the Maratha community and other members of the Morcha who were protesting. It was very clear that 16% was the figure that you wanted.
Yeah, madam, 16% was the figure what we were demanding. But Justice Gaikwad Committee, which gave that report to the Honorable High Court, in that report they have specifically mentioned 12 to 13%. It seems like that from what I gathered the information from my sources. So the small cap between 12 to 30% has to be decided by the government now. Our demand is for 16% only. Hello.
Okay, so will you continue with that demand? Rajendra ji, will you continue with that demand of 16%? Okay, we seem to have lost that line. So either party still needs to decide how they're going to be taking this ahead. But Santya, in what has been made very clear by one of the petitioners here, he's of course further alleging, Advocate Sadavarte here, further alleging that this has not been an entirely neutral decision by the Bombay High Court. It is under influence by the state government, and this needs to be further scrutinized.
While passing the order, Bombay High Court did mention some of the earlier orders on which their decision was based. They have mentioned those Supreme Court judgments as well, and they have also said that as far as the Supreme Court capping on the reservation goes, under exceptional circumstances and for extraordinary reasons, the 50% cap can be exceeded, and the court has depended on the report of State Backward Class Commission, which says that this is an extraordinary situation under exceptional and there are exceptional reasons behind providing this particular reservation to the community. But how exactly all these petitioners are going to take this? As I said, there are more than 50 petitions which are clubbed together, and how many of them are actually going to approach Supreme Court? That is again, each one of them are yet to make it clear that whether or not they are going to approach Bombay High Court. But as of now, it's a Marathas are looking at it as a relief, because as I told you, there were chantings outside. There are still chantings which are happening. In fact, if we can turn the camera around there, you can see that they are also there are flags in their hands, and they are all set to celebrate here, and they have been asked to go a little away from Bombay High Court because they can't do such celebrations here. But the community as of now, especially those people who have gathered outside Bombay High Court, they look happy and in celebrations mode.
All right, so that's just an indication of the happening outside court, but it is of the figure, that figure of 16% that they had continued to press for and demand and protested for, that has once again been brought down by the High Court here. Let's also get in Advocate Akshay Kapadia with us on the phone line. Mr. Kapadia, I appreciate you being with us. Are you satisfied with this balance that has been struck by the High Court, saying that it is a community which deserves reservation, but not as much as 16? It needs to be brought down to 12.
I am satisfied on that aspect. That court has upheld the reservation. That court has concluded that this community needs a reservation, which court has relied upon the report of the Gaikwad Commission. And apart from that, court has also concluded that commission has done his job perfectly. They have balanced the parameters which were required to give the suggestion to the state to provide the reservation. But slight disappointment on the part that the percentage of the reservation has been reduced by the court, but we can cover up to by those state has urged it that will file an application for the modification of the order, or we can also challenge that to the Supreme Court. It is the part that court has relied upon the commission report. The commission have also suggested the same pattern of percentage of the reservation.
Okay, so we got your point. You are satisfied the reservation has now been taken into account even in the court's eye, the High Court's eye, but that 16% continues to remain a contentious issue. Let's get in the first reaction from the BJP. Mr. Vishwas Pathak with us over the phone line. Mr. Pathak, thank you for being with us. Help us understand how is the Maharashtra government here to deal with it. Are they going to be going ahead and considering what the Bombay High Court has said, that this reservation needs to be shot down, or would this further be sought in the Supreme Court?
Yeah, just the Honorable Bombay High Court has announced the decision. They have accepted what we wanted in principally, that there has to be reservation for Maratha community. But whether it should be 16% or 12% was a matter of debate. Actually, after due consideration, this 16% resolution was recommended and it was approved also. We'll examine this judgment and take proper advice. And I think we can always go in Supreme Court and put up our case before them also.
Right. But Mr. Pathak, 16%, if I remember right, in the face of those protests that we had seen, that figure came from the Maratha community itself. 16% was an insistence that came from them, and not as much the calculation of the government.
No, 16%, not only it has come from Maratha community, but it is also on the basis of total population and distribution of, the population share and all that thing. And we also had committee recommendations, and on the basis of that, 16% was made as a law. However, High Court must have observed some other issues. We will examine that, and I think we have still an option to go in Supreme Court to put up our case.
Right, but Mr. Pathak, this was something that was decided by your government last year. It has been implemented this year in the area of education and jobs, carrying on with that 16%. What kind of an immediate impact will today's decision by the Bombay High Court have on ground?
No, we need to examine that, whether it will have retrospective effect or prospective effect. We need to examine that. And we can always go and approach Honorable High Court also to review the matter in case there are some practical difficulties in implementing this order. I think we may go to Supreme Court and put up our case.
Right. Also, Mr. Vishwas Pathak, okay, yes, I would request you to please hold the line if you can. We're getting in a quick reaction here from Mr. Ram Kadam on this decision. Let's take listening.
बहुत ही हर्ष और आनंद की बात है कि माननीय उच्च न्यायालय ने भी आज ये स्वीकार किया कि मराठा समाज को आरक्षण मिलना चाहिए और महाराष्ट्र सरकार की ओर से जो मराठा समाज को आरक्षण दिया था उस बात को लेकर के माननीय उच्च न्यायालय ने उस आरक्षण को वैध करके करार दिया है। इस बात का हम स्वागत करते हैं। एक बार पूरे निर्णय की हमारे पास कॉपी आती है तो हम उसका रिव्यू करेंगे। रिव्यू करके जो 3% आरक्षण कम करने के लिए कहा है उस बारे में फिर से एक बार सरकार उस पर पॉजिटिव सोच रखते हुए आगे बढ़ेगी।